Find a seat. Let's see, was there anybody here that was here almost 3 years ago when Gary spoke to us besides Jack and myself? 2 or 3, okay.
There's a quiz.
I still have my notes.
Can I tell a story about that? I transcribed, I took a picture, just let fellows really know, and I had it at home on the TV, putting it on, and yes, Elaine came watching. He's really good. Boy, he can really explain right down at the and she was just fascinated by the fact it took her away from her work, her housework. I had to evacuate her, and it was just an amazing coincidence. You have to look at that. And so fascinated with your explanations and plainness, the way you're able to explain it in our terms. So appreciate that very much.
Well, that's why we're having him back.
There you go.
Gary's been practicing law here in Fircrest at University Place for probably close to 30 years.
Yeah, well, we don't need to be reminded of that.
Okay, sorry. And I've had the privilege with working with him in the past several times. Great guy, a wonderful friend, and really knows his business when it comes to the things that we're going to talk about, that he's going to talk about tonight. So as we go along, I guess, ask questions as you go along. You want to save them to the end?
No.
Okay, so raise your hand if you have a question about whatever he's talking about, and we'll get into it right then. So, Gary Conant, you want to bring your sentence to the
I'm good. I'm going to walk around, which is going to make it hard for the disc. But... So, hi, everybody.
Hello.
I hope you all got out and enjoyed some of that weather today. It's the least you could have done to spend an hour in here talking about death and taxes. So Bob mentioned about questions. This is much better if we do this as a conversation rather than a lecture. I've been doing this for a long time, and I could lecture at you for an hour. I could lecture at you for a day. We could talk about this stuff, and you could just listen for a long time. But I would rather that we had this as a conversation. So if you've got a question, please interrupt. This is a train we can put back on the track pretty easily. Okay. So Bob asked me to come and talk about some of the things that are important in what we call estate planning. And that's, excuse me, I did some cheering from my Ohio State Buckeyes this weekend. And you got to, if you know, they are pretty easy to cheer for, but I still stood there in my living room and made a fool of myself. But anyway, so bear with the voice a little bit. It's a good thing maybe that I have this after all. Okay, so this estate planning thing is all about making the legal arrangements so that what you have goes to who you want it to go to, when and how and under what conditions you want them to receive it, with a minimum of taxes, costs, fees, and hassle. And along the way, I will argue that maybe the most important part of estate planning has to do with the things that will take care of us, take care of you. The wills that you're going to think of, the trusts we're going to talk about, are all about who comes after us. They're all about who we leave our stuff to. Stuff, by the way, is a term of art, a legal word. The powers of attorney are the documents that say, if I am alive and I need somebody taking care of me, if I need somebody handling things for me, if I need somebody making decisions because I can. The power of attorney is the document that says, here's who I legally authorize to do that. Now, I'm guessing, just a guess, but I'm guessing most of you have visited the doctor recently. My guess is most of those doctors' offices would ask if you have a healthcare power of attorney and a health directive. You're all pretty familiar with what those are? I'm going to bet not. The healthcare power of attorney is maybe the most important legal document you will ever have. I hope you never need to use it, but it is maybe the most important legal document you'll have. It is the single document that says, if I'm in a situation medically where I can't make my own healthcare decisions, whether it's a simple procedure, or maybe the most difficult and permanent of healthcare decisions. If I can't make those, here's who I authorize to make those for me. Now, I'm going to guess most of you have it. I'm going to guess that those of you who didn't see a lawyer to do it got one off the internet. Maybe you used the one that the doctor's office provided, or Group Health has one, or Multicare has one. I'm hoping you all have one. I'm not going to ask for a show of hands. The power of attorney basically says, here's who I give the authority to make these important decisions to. Typically, we appoint our spouse to that. Typically, we don't really need a power of attorney for a spouse to be making those healthcare decisions, but I'm going to tell you that more and more, as the healthcare providers are owned by these giant corporations, we're going to need that even for spouses. Healthcare power of attorney should say, if my spouse is not available, then here's who I appoint to have that authority. What if there's a situation where there's a common accident, or for whatever reason, spouse is not available, or you don't have one? The biggest mistake I see clients wanting to make is to make the decisions about who we're going to give this power to politically. We choose our children in birth order because one was born ahead of the other, not because one is better qualified to make these decisions. Maybe we choose a friend who is 25 years older than we are. If I leave you with nothing after tonight, what I want you to take away is that the most important decision you make about this is who you appoint, who you give this authority to make these important decisions. It needs to be somebody whose judgment you trust. It needs to be somebody who will make decisions the way you will want them made. And it needs to be somebody who can do that comfortably. Not always children, not always the best. And even if it is children or whoever we appoint, I'm going to tell you that if you don't have the conversation with them about it, if you don't talk with this person or these people about what you want under certain circumstances, or what you want them to think about, or how you want them to feel when these circumstances arise, they're not going to know what to do. You're not going to be able to have any comfort that they're going to do what you want them to do. So make sure you've got the document. But most of all, make sure you are thinking through who you're going to appoint, and then have the conversation. You can't anticipate all the circumstances. There's just no way to do that. Frankly, if you're sitting down with kids, they don't want to talk about it anyway. Spouses often don't want to talk about it. So we don't want to talk about it. So it's a conversation that needs to take place if you want the comfort that comes from knowing that if you're facing those circumstances, and you might, we all might, you want to know that whoever is going to be standing there bedside is going to make decisions for you the way you want them made. Have the conversation. Any of you familiar with a tool called the 5 Wishes? Any? Somebody's heard of it. The 5 Wishes is a reaction that was done by a group of people some years ago now. A reaction to the fact that people don't think about all of this. They don't talk about it. They don't have the conversations that I'm trying to encourage you to have. You can find the 5 Wishes by looking online. You've got your phones, you can search it. 5 Wishes is designed to walk you through a variety of scenarios and have you think about how you want things handled, how you want these issues addressed, and who do you want addressing them for you. It is a great tool. So if you're looking for a way to stimulate the conversation, go online, find the 5 Wishes, look through it. If you're really motivated, download it, fill it out, talk about it, use it as the tool that stimulates the conversation. Great tool. But don't get caught. The 5 Wishes suggests that it substitutes as an acceptable power of attorney in a number of states, one of which is Washington. I was also cheering for the Huskies. It does not substitute for the legal document that is your healthcare power in Washington. So let's go back and talk about the healthcare power of attorney a little more. There is nothing in the law that says a doctor, a hospital, a care facility, a bank, a title insurance company, an investment place, there is nothing that says any of them have to accept or honor your power of attorney. Nothing. It is a courtesy. It is something they will honor if they have some comfort that it was done properly, that you had decent advice when you filled it out or signed it. It is a tool that if they aren't comfortable, you know how to use that tool and you did it properly, they're more inclined to honor it and accept it on your behalf. Dwayne.
Along that same vein, we all travel some, and how does that go if I'm in Mexico or South America? How do they have much faith in our power of attorneys down there?
If you're in Mexico or certain places in South America, I'm going to question your sanity to begin with. It's always, I always invite my clients to take copies of their powers of attorney when they travel. These days, I created an envelope that just has the copies of the healthcare powers of attorney and the healthcare directives, and I say, when you travel, toss this at the bottom of your suitcase. One, because I'm a great believer that the more prepared you are, the less likely it is you're going to need it. And two, because having something is better than nothing. Okay? So I can't stand here and say that if you're in Mexico or anywhere, I can't guarantee you that it's going to be honored. If you're in Multicare or St. Joe's or St. Anthony's, I can't guarantee you that they're going to honor it because they don't have to. Okay? So all you can do is take the tool along. Anything else? Okay.
I've got a question. When you say they don't have to, what would they do then in that situation if they're not going to follow your doctrine?
Well, let's play that out a little bit and pretend we're at St. Joe's.
Okay.
Where I know the corporate philosophy about end-of-life issues is very different than it is at Multicare. If you have a son who's standing there with your power of attorney claiming he has the authority to make your health care decisions, and that power of attorney was obviously pulled off the internet, it's a bunch of check the boxes, maybe it's got your signature on it, maybe it doesn't. Maybe it's even a completed, filled out 5 wishes document that's multi-page. If they don't like it, if they're nervous about it, if they are worried that somebody in the legal department is going to get on their case for accepting it, they're not going to. They don't have to, in which case they're either going to say, you go get a court to tell us what to do, or go get a court order, or we're going to follow our policy, which is we're going to put you on a respirator, we're going to do whatever we need to do, or worse of all, they're going to follow what the insurance company that's being asked to pay for it is advising them. Yeah, that's sort of the reality we live in these days. Other questions about this? So the 5 wishes is a really valuable tool to use. Do not think that it substitutes for a properly prepared legal document that is your healthcare power of attorney that is reasonably current. Some of you I know have powers of attorney that are not so reasonably current. Get them up to date. Even if all we're doing is changing the date and re-signing them, keep them current, because that helps with the credibility of the document. Okay?
Is this something that should be notarized?
The power of attorney would typically require a notary for your signature, as opposed to a healthcare directive, which we'll talk about now. Anybody know what a healthcare directive is in Washington?
Is that the same as advanced directive?
It's, some people call it the advance directive, some people call it a living will.
Military uses that.
Yeah. So, healthcare directive doesn't require a notary, but it requires 2 witnesses to your signature. I can't explain. The healthcare directive is Washington's version of what every state has that is typically thought of as a living will. And it's designed to say, if I'm dying, my preference, my request is that nobody go to any extraordinary measures to prolong what's going to happen anyway. Well, words like preference and request have no legal significance. It doesn't say you shall plug me in or you shall not plug me in. There isn't a check the box that says plug me in or not. There isn't. It says please. Please don't go to any extra measures to prolong this. Now, obviously that's subject to lots of interpretation. So, the healthcare directive in Washington is a document that's written largely by the state legislature. It is what we've had. I always argue that these days we are far more humane to our animals than we are allowed to be to each other and to ourselves. The fact of the matter is that's where we are. We are not culturally evolved enough yet that we can control our own destiny. The closest thing Washington gives us to get close to that is the healthcare directive, which is very, very weak. So why do you care if you have it? Well, if you have it, it's important when you go to the hospital or you see the doctor, because the doctor and the hospital are required to ask if you have one. If it's so weak, why? Well, if they ask if you have one and you say yes, that's what will give them the legal comfort to turn to whoever has that power of attorney and say, okay, here's what's going on, what do you want us to do? If you don't have a health directive, or an advance directive, or a living will, if you don't have that, then what happens is that they presume you don't have it because you're choosing not to have it. The only reason you would choose not to have it is that you don't want family making these decisions. You'd rather it is whatever doctor that's on call at the moment. Maybe the hospital policy, and again, I will tell you that policy is very different at St. Joe's and St. Anthony's than it is at Multicare. Maybe it's being influenced by that insurance company that's being asked to pay for it. So the healthcare directive is important in Washington, not because it says what you want it to say. It's important because it allows the people who will say what you want them to say to speak for you. Follow that? So power of attorney is really important. Nobody has to rely on it. It's a courtesy if they will look at it and use it for you. They are more inclined to extend that courtesy if you have the health directive, and more inclined if you have these things in order to let the people you're appointing make these decisions. But again, if I leave you with anything, it is, I don't care about the documents nearly as much as having the conversation with the people who will be standing up. Help them to know what to do. Not just because you want them to do what you want them to do, but because it's making it so much easier for them. How many of you have had to stand there and deal with these issues for parents or friends? It's hard. It's a really difficult place to be. But I will tell you from personal experience and from watching lots of clients, that is easier. It's never going to be easy, but it's made easier if you know what they want you to do. If you know what they want you to say. Questions? Okay. So I said the health directive is really weak. The doctors and their association, the American Medical Association, reacted to how weak the healthcare directives are nationwide, and they created a document called the POLST. Does that sound familiar to anybody? POLST, POLST. It stands for Physicians' Orders for Life-Sustaining Treatment, POLST. You may have seen it. It is typically printed on a really ugly green, almost cardstock paper. Now it's familiar. That document is an agreement, sort of, between the patient and the doctor. It's not a legal document, it's an agreement between the patient and the doctor about how you want particular kinds of things handled at end of life. The post is typically what we see or what we hear about that's hanging on the refrigerator door for people who are terminal or for folks who just like to keep that stuff out and available. It's not great refrigerator art, but it is what it is. The Post is available at your doctor's office. If it's something you want to look at, you should talk to them about it. It is something that as a patient we sign and the doctor signs with us.
Does the doctor need to sign it?
In order for it to be useful, yes. I mean, it's something that results.
My doctor wouldn't sign it.
Wouldn't sign the Post? Well, that may be because, that points up a really obvious point, which is every doctor treats all of this stuff different. They've all come from different medical schools, they're coming into different environments, they're trying to work in an environment, and some of them in St. Joe's, and then go down the street and work in multi-care where it's all different. I mean, I get it. I mean, I get that the doctors don't want to do this stuff, and they are being preached at more often than I like to think about by the vast legal teams in these giant hospital corporations that say, don't sign anything that puts us at risk. So, I get it, but the doctor needs to sign it. It's the document that if 911 is called, they're going to look for, because that's the document that will help manage how much work they do and what kind of work they do.
Can you put this in, like in the county? They have my birth certificate, they have my DD 214, they got a copy of everything. Can they use that?
Can you record it? You can go down to the county recorder's office over there behind Costco, and you can record almost anything. So yeah, you can put it in there. I've never heard of that or never seen it.
Will they just look?
No. And if they are, if that's where it is, nobody's ever going to find it. And if 911's being called, they're not going to stop and ask where your computer is and what's your password so they can get in and go to the Pierce County Auditor's office and look it up. It's not going to happen.
If you told them it was there, could they go get it?
I don't see any value in recording it for you. Just
Because
if
if
it-
you
if
didn't
it's
have
a-
any friends, and you don't have a home, so to speak, where would you put it?
Maybe in your pocket, maybe.
Could you condense it down to a small card?
Who is your doctor? I don't mean your doctor, I mean, when you say your doctor, which one?
It's whoever you are seeing recently. I mean, I get that problem too. We used to have a doctor that knew us, that he called us by our name when we were in there once a year. I mean, I get that. That doesn't happen anymore, but virtually any doctor that's connected to the organization you're part of should be able to have that conversation with you.
Sometimes there's many.
I understand the frustration. There are many lawyers too, and none of them all are very good.
I think in this day and age with electronic medical record, in some cases, if you have some of these documents, you can, if you know for the most part what hospital you might be treated at, you can have that scanned into your medical record.
Yep.
And then when I put your name and date of birth in and bring you up, you have to, you're in the hospital, I'm not in your kitchen trying to do CPR, but then I'm gonna know right in that electronic medical record where to go to find the
Yeah, that's a great point, because that's something else that's evolving these days, is part of the reason the doctors and the hospitals want these things is because they want to scan them. They'll put them into your electronic file, which may solve the issue for you. And once it's there, that's great. Then you don't have to fold it up and carry it in your
Yeah,
pocket.
because the VA's got my record,
Yeah, and they would,
and I have the advanced directive.
yeah, and they would scan it and keep it in there. That's perfect. And my guess is they would do that with the Pulse too. My guess. For the VA, they would need to go through some series of regulations and issues and try and figure out who has the authority to do whatever.
Yeah, don't wait too long.
Okay, so bottom line, those are really important documents. They're really documents I hope you never have to use, but if you have to use them, they need to be done right. And most important of all, they need to appoint the people that should have the authority to do that, people who will make the decisions you want them to make, people who have benefited from the conversation you're going to have with them. Okay? All right, the other power of attorney is a financial power of attorney. That's the one that says, here's who I give the authority to write my checks, to sign anything I could sign, to sell my house if need be, to take care of my bills on a recurring basis, to take care of anything I could take care of, anything I need to deal with on a day-to-day basis. Very, very powerful document. It's not often, but in the time that I've been practicing, I've seen circumstances where they've been abused. Not often, but I'll always argue that the abuse is a function of not picking the right people to do this. When you appoint people simply because of birth order, it's not always the smartest decision. Maybe it's politically popular in the family, but not always the smartest decision. Again, even with financial powers of attorney, no obligation on the part of the bank or the title insurance company or the investment place, no obligation for them to honor it. So the more official it looks, the more signatures are notarized, the more it addresses the kinds of things that should be addressed, the better. We've had some recent changes in the law about what they like to see in powers of attorney. So now, apart from the obvious sorts of things, now we have to have provisions that allow the attorney in fact, or the agent, the person who's working on your behalf, to have the authority to talk to insurance companies. They need specific language about that because the insurance companies are persnickety. We need particular language for your digital assets. That's brand new. The last few months, we have to have language in there that allows somebody to get access to your Facebook account and your Google passwords and all of the other stuff that we do digitally these days, banking online. We need specific language to make sure somebody's got the authority to talk to credit card companies. And we need specific language that allows somebody to act on your behalf to talk to utility companies. So you can't just call up Comcast or Tacoma Electric Utilities and say, I've got the power of attorney. They're going to say, well, we need to see it, and we also need to see that you're specifically authorized to deal with utility accounts. It's getting crazy out there. And I don't have to tell you that, but it is getting crazy out there. And everybody's worried about covering their backside, and so all of these language changes are happening on a regular basis.
Barry? Just in that